Hi, this is Dr. Perry Carpenter. Welcome back to session number 2 in our game show quiz on the QME regulations. In our last session, we quizzed our knowledge on the important labor code 4060. And just to review very briefly here, we stated that Labor Code 4060 is one of the important labor codes that governs the QME panel process. It's responsible for giving us a significant percentage of the phone calls that we receive, or I should say the requests that we receive for QME examinations. So Labor Code 4060 is the labor code that deals with those claims that have been either denied or delayed. In other words, when there's a dispute over the compensability of a claim, it's Labor Code 4060 that governs the resolution of that dispute. Now, as we're going to see in today's session, when we go into a discussion of Labor Codes 4061 and 4062, we're going to see that these three codes, which are the three primary codes that govern the QME panel process, these codes are interrelated and interlinked, although they initially begin by discussing different types of disputes. And 4060, as we said, is the code that we refer to for the resolution of disputes that are associated with compensability. So today we'll talk about what types of disputes are resolved under Labor Code 4061 and what kinds of disputes are resolved under Labor Code 4062. So we're going to handle those two codes in today's session. And then in our next session, we're going to talk about the important language found in Labor Code 139.2. And then following that, in our next session after that, we're going to conclude our game show quiz with a discussion of Labor Code 4628. So stay with us on each and every session. These are critical codes that are intimately and intricately related to the day-to-day work that we do. Okay, so with no further ado, let's begin today's game show with our discussion on Labor Codes 4061 and 4062. Okay, let's begin today's game show, and today let's focus our efforts on Labor Codes 4061 and 4062. And we're going to see that these three labor codes, 4060, 4061, and 4062, are all linked and hinged together at the hip, but they initially begin by discussing different types or different uses of the procedures that are described within each of the labor codes. So let's begin here and let's talk about Labor Code 4061, and we'll go through a series of questions here, and then we'll go through a series of questions regarding 4062. Okay, so for 10 points, true or false? Labor Code 4061 deals with disputes over the existence and extent of permanent impairment and/or the need for future medical care. Is that true or is that false? Is 4061 involved with permanent impairment and future medical care? True or false? Well, that's true. That's true. As we're going to see, Labor Code 4061 does indeed deal with disputes over permanent impairment and disputes over the need for future medical care. As we discussed in our last session, Labor Code 4060, that's the code that deals with disputes over compensability. So between 4060 and 4061, we have compensability issues, and we have permanent impairment issues, and we have the need for future medical care issues. And that leaves us 4062 as sort of a catch-all funnel labor code that deals with disputes over what we're simply going to refer to as other issues. So between the three codes, we have a mechanism for dealing with disputes over all possible issues. 4060 has dedicated use for compensability. 4061 is dedicated for use with disputes over permanent impairment and future medical care. And then we have the garbage bin, so to say, of 4062, which is involved with all other issues. Okay? So we're talking about 4060 in this series of questions, and 4060 is involved with disputes over permanent impairment, and that includes whether there indeed exists permanent impairment, and if permanent impairment exists, what is the extent of that permanent impairment, and also disputes over the need for future medical care. Okay? Okay, now, next question for 20 points. True or false? If there's a dispute over the compensability of an injury, we refer to the procedure described in 4062 for the process to obtain a QME panel. Now, this might seem like we're jumping amongst codes. Here we are talking about Labor Code 4061, and we jump backwards to talk about issues related to Labor Code 4060, and then we jump forward here to talk about some procedures described in 4062. Well, how does that relate to Labor Code 4061? Well, it relates to Labor Code 4061 because regardless of the nature of the dispute, whether we're talking about compensability disputes, permanent impairment disputes, or disputes over all other issues, it's, as we're going to see, it's Labor Code 4062 that gives us the process for requesting a panel QME. And this applies to both represented and unrepresented injured workers. So we're going to see that Labor Code 4062 is going to be a critical code to understand because we're always going to jump into Labor Code 4062 regardless of the dispute. Regardless of the dispute, we're going to jump into Labor Code 4062 to give us the process for requesting QME panels for unrepresented injured workers and also represented injured workers. And that applies even to disputes under Labor Code 4061, which is what our current concern is. Okay, next question for 30 points under Labor Code 4061. Under Labor Code 4061, is this true or false? Only the employer may request a comprehensive medical evaluation to resolve disputes over the existence and extent of permanent impairment when the employee is unrepresented. Unrepresented. Okay, so we're not talking about represented injured workers, we're talking about unrepresented injured workers. Maybe this question could be rephrased to ask, with an unrepresented injured worker, who has the authority to request a medical evaluation to resolve the dispute over the existence and extent of permanent impairment? Who has that authority? Is it only the employer? Well, no, it's not only the employer. So the answer to that question is false. And here Labor Code 4061C gives us instruction on this issue. It says that either party, that's the employee and the employer, may request a comprehensive medical evaluation to determine permanent disability or the need for future medical care. And in that case, when one of the parties does request a comprehensive medical evaluation, the evaluation shall be obtained only by the procedure provided in Labor Code section 4062.1. And of course, for 4062.1, and as relates to this question, we're talking about unrepresented injured workers. So let's imagine this scenario. We have an unrepresented injured worker who's gone through a period of treatment, and they get to the end of their treatment and they're declared to be permanent and stationary, and the claims administrator disputes the level of permanent impairment rendered by the primary treating physician. Well, in that case, the claims administrator or the employer then has the authority to request a comprehensive medical evaluation. And also the opposite scenario applies as well. Let's say the injured worker, the unrepresented injured worker, goes through a period of treatment and they're declared to be permanent and stationary by the primary treating physician. And the primary treating physician renders an opinion of, let's say, 0% whole person impairment. I'm just using this as an example. The injured worker might dispute that fact. They may feel that they do have some permanent impairment and they do have some residual problems. And in that circumstance, they then have the authority to request a comprehensive medical evaluation to resolve the dispute over permanent disability or permanent impairment. So it's important to remember that either party has this authority, and that's very interesting. So under 4060 and 4061, either party has the authority to request an evaluation. So when we get to Labor Code 4062 and we talk about other disputes, do you think it's possible that either party or any party has the authority to request a comprehensive medical evaluation? That's probably what we're going to see, but we'll wait until we get there to solve that riddle. Okay, let's go on now to our next question. Okay, under Labor Code 4061 now for 40 points. Under Labor Code 4061, when an unrepresented injured worker has a QME evaluation and they receive the QME report and they note factual errors in the subsequent QME report, they are basically out of luck and without recourse. Is that true or is that false? And let me ask you this. Have you ever issued a QME report and had either the employer or the employee dispute some factual errors contained within your report? I think in my own career, I think I can remember that happening like once. It's certainly not something that occurs with any regularity, but I think, and this goes back some years, I think that may have happened to me like once or so. But what if indeed there are factual errors contained in the QME report? Where does that leave the unrepresented injured worker? Well, that's false. The unrepresented injured worker is not basically stuck, and they're not basically out of luck, and they're not without recourse, because Section D1 of 4061 says that within 30 days of receipt of a report from a qualified medical evaluator who has evaluated an unrepresented employee, the unrepresented employee or the employer may each request one supplemental report seeking correction of factual errors in the report. And of course, any and all of these requests have to be made in writing. So, doctors, it's important to get your facts correct, both on the testimony of the unrepresented employee and also on all other facts contained within your report, because both parties are going to be scrutinizing your report for factual correctness and factual consistency, and especially unrepresented employees are quite sensitive to this, and they pick right up on factual errors contained within the report. So if that happens, don't be surprised if you get a request from the unrepresented employee for a supplemental report to seek correction of those factual errors. Okay? And then finally, Labor Code Section 4061 for 50 points. Final question, under Labor Code 4061, all final permanent impairment opinions must be offered by the qualified medical evaluator. Is that true or is that false? Or perhaps another way to ask this question is, under Labor Code 4061, who has the authority to issue opinions on permanent impairment? Is it only and solely and exclusively the qualified medical evaluator, or does perhaps also the primary treating physician have the opportunity to issue an opinion on permanent impairment? Well, the answer to that question is false. The permanent impairment rating can be offered not only by the qualified medical evaluator, but can also be offered by the primary treating physician. And let's read this section of Labor Code section 4061G in its entirety. It says, within 30 days of receipt of the rating, if the employee is unrepresented, the employee or the employer may request that the administrative director reconsider the recommended rating or obtain additional information from the primary treating physician or from the qualified medical evaluator to address issues not addressed or not completely addressed in the original comprehensive medical evaluation or not prepared in accordance with proper procedures. Of course, this request shall be in writing. It shall specify the reasons the rating should be reconsidered and shall be served on the other party. So if the unrepresented injured worker does not feel that your permanent impairment rating is an accurate representation of their condition, they can request a reconsideration, and they submit this request to the administrative director. And of course, they have to specify the reasons that they're requesting a reconsideration. Now, if the administrative director finds the comprehensive medical evaluation is not complete or is not in compliance with the required procedures, the administrative director shall return the report to the primary treating physician or the qualified medical evaluator for appropriate action as the administrative director instructs. Upon receipt of the treating physician's or qualified medical evaluator's final comprehensive medical evaluation and summary form, the administrative director shall recalculate the permanent disability rating. So, quite interesting. I think what's important to note throughout these codes that we're reviewing is that at all stages of the process, both the employee and the employer have similar rights and similar authorities. And at least as relates to this section of Labor Code 4061, if either of those parties feel that the permanent impairment rating is not a true and accurate representation of the injured worker's condition on the date of your evaluation, either one of those parties can request a reconsideration. And so don't be surprised if you receive those requests to have your permanent impairment rating reconsidered, and it's the administrative director that then provides the instructions for us as to how to proceed or how to properly prepare our report so that it complies with all procedures and that it addresses all issues. Okay? Okay, so let's move on now to Labor Code 4062. But before we do that, let's just summarize Labor Code 4061. And that is that 4061 is the code that we refer to for the resolution of disputes over two simple issues. And that is the existence and extent of permanent impairment. That's one issue, the existence and or the extent of permanent impairment. And then number two is disputes over the need for future medical care. So for example, the employer may contend that there's no need for future medical care, while the employee may contend that certainly there is indeed a need for future medical care. So those types of disputes are resolved under Labor Code 4061. Okay, let's go on now to Labor Code 4062. Okay, and just a couple quick questions on Labor Code 4062 for 10 points. True or false? Under Labor Code 4062, prior to issuing a QME panel, the medical director requires that both unrepresented and represented workers attempt to agree on an AME. Okay, prior to issuing a panel, do the parties have to attempt to agree on an AME? Is that true or false? Well, of course that's false, and certainly it's false as relates to unrepresented employees, because that would certainly put the claims administrator or the employer at an advantage, because the employee has no way to know of any doctors, any medical evaluators. They have no way to have a basis upon which to agree to any type of a doctor. So that would certainly put the claims administrator at an advantage. And I'm sure you can imagine the conversation between the employer and the employee over this issue. Imagine this. The employer calls up the employee and says, okay, so we're going to order a comprehensive medical evaluation for you in order to determine the compensability of this claim, or to resolve a dispute over the permanent impairment. And I wonder what you think about having Dr. Smith. He's a well-known medical orthopedic doctor whose office is very close to your work address. Would you agree to use Dr. Smith? Of course, that would place the claims administrator at a tremendous advantage, because the injured worker, the employee, they don't know Dr. Smith. They don't know any doctors. These are lay people. So for unrepresented injured workers, we don't use agreed medical evaluators. Well, what about for represented injured workers? Well, even so, it's still false, and this represents a recent change in the law. Under Section 4062.2F, it states that the parties may agree to an agreed medical evaluator at any time, except for certain issues related to medical treatment and independent medical review. But the substance of this statement says that the parties may agree to an AME at any time, but they're not required to. And this represents a new change representing the passage of Senate Bill 863 in 2013. It used to be that for represented injured workers, the parties had to demonstrate to the medical director that indeed they did try to agree on a medical evaluator, but they weren't able to agree, and so that for that reason, they're requesting a panel of 3 qualified medical evaluators. Now that part of the law and that part of this labor code has changed to reflect the fact that they can agree, they have the option to agree, but it's now not required. It is not required. So the answer to that question is false. Okay, Labor Code Section 4062 for 20 points says that under 4062.1, either party, and here we see the resurgence of either party again, says either party may request a QME panel. However, the employee cannot request the panel unless the employer has not requested a panel within 10 days of receiving the form from the medical director. And that is the form to be used for requesting a QME panel. So is that true or is that false? The employee cannot request the panel unless the employer has failed to request the panel. Well, that's false, and the reason that it's false is because it's the employee, not the employer, that has the first option to request the panel. And this is stated in section 4062.1b. It says that the employer may not submit the form unless the employee has not submitted the form within 10 days after the employer has furnished the form to the employee and requested the employee to submit the form. Okay? So imagine this. The employee requests a comprehensive medical evaluation to resolve some dispute. Okay? So in that case, the employer furnishes the form to the employee to be used to request a QME panel. This is the form, I believe it's QME form 105. I believe it's 105. And the employee is to fill it out and send it to the administrative director in Oakland. Well, if the employee sits on that form and does not submit the form within 10 days after receiving the form, then of course the employer can then submit the form and request the panel, but it's the employee that has the first option on the panel. Okay? Okay, Labor Code Section 4062 for 30 points. Yeah. An unrepresented employee, is this true or false? An unrepresented employee can discontinue the medical evaluation if they do not like the doctor. Is that true or false? This is an unrepresented employee. Can they discontinue the medical evaluation if they don't like you? Well, the answer to that is both false and true. False and true. The reason it's false is because the unrepresented injured worker cannot simply discontinue the evaluation based on the fact that they don't like you. In other words, the fact that they don't like you. They tell the medical director that, I just didn't like that guy. I didn't like him. That's not sufficient cause to discontinue the evaluation. But it's also at the same time, it's actually true. Because if the injured worker can establish good cause for discontinuing the evaluation, they can receive a new panel of medical evaluators. And it can simply revolve simply around the fact that they don't like you. Now, the language involved with establishing good cause is slightly different, but it really actually revolves around whether or not they like you. So let's read this code section in its entirety. It says that the evaluator, which is you and I, shall give the employee at the appointment, a brief opportunity to ask questions concerning the evaluation process and the evaluator's background. In other words, so we're to give them the opportunity to get to know us a little bit and get comfortable with us a little bit and to ask us some questions and actually take a little bit of control over the process. So once that's done, it says that the unrepresented employee shall then participate in the evaluation as requested by the evaluator, unless the employee has good cause to discontinue the evaluation. For purposes of this subdivision, good cause shall include evidence that the evaluator is biased against the employee because of his or her race, sex, national origin, religion, or sexual preference. Or if there's evidence that the evaluator has requested the employee to submit to an unnecessary medical evaluation. So basically, if they don't like you, if they feel that you're biased against them because of the way they look, the way they talk, the way they act, the way they dress, their religion, their heritage, their national origin, their religious preference, their sexual preference. If they don't like you, and they can establish good cause based on these specific languages, all they have to do is they say, he was biased against me because of whatever, because I'm Spanish, or I'm from France, or because I'm Muslim, or whatever, then they can discontinue the evaluation. So this section is both false and true. So it's important that you behave professionally, that you behaved in an unbiased and objective and neutral fashion with your examinee, and it's important that you establish rapport with the examinee, and it's important that the examinee actually like you. Otherwise, like in any relationship, you can be replaced. Okay, Labor Code Section 4062 now for 40 points. Under 4062.2, either party may request a QME panel. The requesting party must disclose the specialty of the primary treating physician. Is that true or false? Well, that's true. The party submitting their request shall designate a couple of specialties. Shall designate the specialty of the medical evaluator that they're requesting. They shall designate the specialty of the medical evaluator which has been requested by the other party, if it's known, and also must designate the specialty of the primary treating physician. And the party submitting the request form shall serve a copy of the request form on the other party. And this is where disputes over the specialty of the medical evaluator arise. And one of the things that the medical director looks at in resolving disputes over the specialty of the evaluator is the specialty of the primary treating physician. So, for example, if the specialty of the primary treating physician is neurology, then the medical director is going to look towards neurology as the most appropriate type of medical evaluator to perform the medical evaluation. And it's the specialty of the primary treating physician that's given great weight in resolving disputes over the specialty of the QME panels. Okay? And then finally, Labor Code 4062 for 50 points. True or false? True or false? After the QME panel has been issued, each party strikes the name of one doctor from the panel. So this is dealing with a represented injured worker. We now have panels at the office of the applicant attorney. We have the panel at the office of the defense attorney. Both of those attorneys take a look at the panel, and each party strikes the name of one doctor from the panel. This is called the strike-strike process. We get two strikes, and we have one last man standing. The last man standing is the evaluator, I should say man or woman, is the evaluator who's going to get this case. So true or false, this last man standing serves as the Agreed Panel QME. And perhaps this term could be put in quotations. It's the Agreed Panel QME. Is that true or is that false? Well, that's false. That's false for a couple reasons. And let me spend just a couple minutes talking about this, because I receive calls from doctors who are confused on this issue. First of all, it's false because the Agreed Panel QME no longer exists, and this represents a recent change in 2013 with the passage of Senate Bill 863. We used to have a designation known as the Agreed Panel QME, and the Agreed Panel QME arose in the following way. Okay, so first, when a dispute arose and the parties decided that it became necessary to have a comprehensive medical evaluation. The parties were supposed to come together and attempt to agree on an agreed medical evaluator. This was the first step. They had to demonstrate to the medical director that they tried to agree on a medical evaluator. If they were unable to agree on a medical evaluator, then the medical director in Oakland at the Division of Workers' Compensation would issue a panel of 3 doctors. Well, at that point, once the parties received the panel, then they were supposed to come together again. They were required to come together again and look at the 3 names on the panel and attempt to agree on one of those doctors to perform the evaluation. We have Dr. Smith, Dr. Jones, and Dr. Thompson. So the parties would come together and say, I don't like Thompson, and I haven't heard anything about Jones, but would you agree to use Dr. Smith? And the other party would say, ooh, I hate Thompson, but I don't know anything about Dr. Jones. Sure, I guess we can use Dr. Smith. Sure, yeah, let's use Dr. Smith. And then Dr. Smith became known as the Agreed Panel QME. Well, with the passage of Senate Bill 863, this step has been omitted, and the parties now are not required, they're not required to attempt to come together to try and agree on a doctor from the panel. So we simply have the strike process and the last man standing. So let's read about the strike process here in 4062.2c. It says, within 10 days of assignment of the panel by the administrative director, each party may strike 1 name from the panel. The remaining qualified medical evaluator shall serve as the medical evaluator. If a party fails to exercise the right to strike a name from the panel within 10 days of assignment of the panel by the administrative director, the other party may select any physician who remains on the panel to serve as the medical evaluator. So this is important. I said the first reason that the last man standing is not the Agreed Panel QME is because the Agreed Panel QME no longer exists. But the second reason, and this is what I explain to doctors who call me on the phone, and these doctors insist that the last man standing is the Agreed Panel QME. And I tell them, no, first of all, Agreed Panel QME does not exist. And then secondly, you're not the Agreed Panel QME because no one agreed to use you. You're simply the last man standing. You're the last person not struck. That's not an agreement. You're simply left there, the last man standing. So there's been no agreement. There is no such thing as the Agreed Panel QME. You're not the Agreed Panel QME. So as a practical application of this code, I just want to close this section by saying that when you get a call from one of the parties in a represented injured worker case, always inquire as to whether or not you're the last man standing, or whether, for example, you are the doctor who has been simply chosen by the party when one of the parties has failed to exercise their right to strike a name. Find out how the strike process unfolded to confirm that indeed the proper process has been followed and that both parties agree that you are the last man standing and you are the doctor assigned to the case. Okay, so these are some things that I've had to learn the hard way myself after losing some cases and making appointments when the strike process has not been properly executed. And so I share these with you so you won't suffer the same disappointments that I've suffered in the past. Okay, so let's now wrap up this section. Okay, doctors, that concludes our second session of the game show quiz. And I want to ask you, how are you doing? How are you doing on these questions? Are you getting some of these questions correct? If so, you should applaud yourself. If not, don't be worried or surprised. I find that I myself start to forget these labor codes if I don't review them routinely. So I hope that this review helps keep you sharp and on your toes as regards the QME panel process. So let's just conclude by saying that we have three codes that govern the QME panel process: Labor Code 4060, 4061, and 4062. 4060 deals with issues over compensability. 4061 deals with disputes over permanent impairment and the need for future medical care. And then 4062 is sort of the wastebasket bin that we turn to for disputes relating to all other issues but those three issues covered by the other two codes. Well, regardless of the nature of the dispute, we then refer to Labor Code 4062 for the process of issuing the QME panel. And for unrepresented injured workers, we refer to Section 4062.1, and for represented injured workers, we refer to Section 4062.2. And I think it's important for you to work through this sequence mentally each and every time you get a request for a QME appointment, because it really helps to understand what it is that you're going to be doing in your evaluation when you know what type of dispute it is that you're being called upon to resolve. And it helps to know which labor code this evaluation is being ordered under. So trace this process through mentally in your mind. If not mentally, you can even do it on paper. And specifically as regards the strike process, it's important to make sure that you get double confirmation, double confirmation from the parties that you indeed are the last man standing, and that both parties are in agreement to use you as the evaluator. That way you can secure the case and not go through the unnecessary time, effort, and expense of scheduling an appointment, completing an appointment notification form, and all of that administrative stuff, only to have the appointment drop out on you. So doctors, I hope this review helps you. I look forward to being with you tomorrow as we shift gears a little bit and we go into two more important labor codes, the first one of which is 139.2, and then we'll talk about Labor Code Section 4628, and I'll share with you some valuable insights and nuances and insider's tips, actually, as to how to use these codes to your own benefit. So this is Dr. Perry Carpenter. I look forward to being with you again tomorrow as we continue our game show quiz on the QME regulations.